Welcome back to the deep dive. Today, we're diving into something uh, really foundational, absolutely critical if you're stepping into the world of law, especially English law.
That's right.
We're not looking at a specific complex case today, not yet anyway. We're going straight to the source on how you actually master one of the most important subjects out there, evidence law.
hmm Think of it like getting the user manual before you try to assemble something really complicated.
Exactly. And our source today is, well, it's invaluable. We're looking at excerpts from Topic 1 Introduction to the Study of Evidence Law.
And this isn't just any old document. It's part of a module guide, specifically made available by the University of London for its students.
Yeah,
A fantastic resource.
it really is. It's like having an experience guide telling you how to approach this journey, how to get the most out of your studies.
Precisely. It sets you up for success.
And we need to make something crystal clear right at the start. This deep dive is brought to you by Sinorbit Academy, Sri Lanka, and it's strictly for educational purposes only.
Absolutely. We're here to help you understand this guide, to unpack it, but we're not a replacement for your main course materials or your own hard work.
Definitely not. Our mission here is to pull out the key insights, the core philosophy, the really practical advice from this introduction.
We want to help you grasp the how of learning evidence law, give you a bit of a head start maybe on navigating all the materials effectively.
Figure out what resources are absolutely essential. How should you tackle each chapter? What does success actually look like, especially when the exams loom?
Yeah, think of this as your shortcut to understanding that study strategy, straight from the guide itself.
And honestly, evidence law, it's just fascinating in its own right, isn't it?
Oh, totally. It's not just dry rules.
No, it's about that fundamental quest for truth within, a proper legal structure. It's key to the fairness, the integrity of the whole trial process.
And it's such a dynamic mix. You've got ancient common law principles bumping up against very specific acts of parliament.
And it draws on fields you wouldn't necessarily expect, like psychology, logic.
Exactly. It's where these abstract legal ideas meet the messy reality of, well, human beings. Memory, perception, trying to prove things that happened in the past. It's challenging stuff.
Okay, let's not hang about then. Let's unpack what this guide says. We'll start right at the beginning, just like the guide tells you to. Section 1. What actually is evidence law, according to this guide? And why should you care? Why is it so important?
Right. So the guide defines it by what it does, its key functions in the legal system. First off, it's the gatekeeper. Evidence law regulates the admission of evidence in court.
The gatekeeper. I like that. So deciding what gets through the door.
Precisely. What information, what documents, what witness testimony is even allowed to be put before the judge or the jury? That's the first hurdle.
But it doesn't stop there, does it, once something's admitted?
No, not at all.
Yeah.
Then the law of evidence governs the use that can be made of that evidence during the trial. Well, think about it. A piece of evidence might get in for one specific reason, maybe to show a witness isn't reliable. But you can't use it as direct proof the defendant committed the crime. The rules dictate how that admitted evidence can be properly, legitimately used.
Okay, so admission, then use. And thinking about trials, especially with juries, there's that crucial bit after all the evidence is in.
Absolutely. The guide highlights that evidence law deals with the judicial directions given to the jury.
The judge is summing up.
Exactly. The judge doesn't just say, off you go and decide. They have to give very clear, specific legal instructions, how to evaluate what they've heard, the relevant legal tests, how to apply the law to the facts they've found. These directions are incredibly important in shaping how the jury decides.
Wow. So admission, use, directions, it really does seem to touch every part of the trial.
It does, and it goes even deeper. It establishes fundamental features of the trial process itself, like which party has to bring the evidence on which particular fact.
The burden of proof.
That's the one, the core concept of the burden of proof. Who has the job of proving a specific point? Evidence law sorts that out. And linked to that, it clarifies the standard of proof needed.
Right. Beyond reasonable doubt versus balance of probabilities.
Precisely. Is it the high criminal standard, beyond a reasonable doubt, or the civil standard, on the balance of probabilities? These rules are fundamental to how the whole system works, how fair it is.
Burden and standard proof. Yeah, you hear those terms early on, but evidence law is where you really see them in action. So beyond these functions, just how important is this subject overall for legal studies, for actually being a lawyer?
The guide is pretty blunt about this. It says evidence law is of huge importance to legal practice.
Huge importance, okay?
Yeah, this isn't just some academic hoop to jump through. It's a practical necessity. The guide points out it's taught on all the vocational courses, the LPC, the bar course. You need to know this stuff to qualify.
So no escaping it if you want to
Yeah.
practice. And what's the payoff for really digging into it early?
The guide says explicitly, studying it in depth beforehand makes you better equipped to become an effective advocate.
Right.
Knowing the rules lets you build your case effectively, challenge the other side's evidence properly, make the right arguments to the judge. It's your toolkit for the courtroom.
That makes perfect sense. It's the engine driving the trial, really. Now, you mentioned earlier it draws on other fields, which sounds interesting, but maybe challenging too.
It is, and that's part of what makes it intellectually stimulating. It's inherently interdisciplinary. Evidence law is trying to help the legal system reach accurate, factual conclusions, right?
Boy.
So it has to incorporate insights from elsewhere. The guide specifically mentions science, especially findings about human perception and memory.
Ah, like eyewitness testimony reliability.
Exactly. It points ahead to later chapters in the guide, chapter 6 and 10, which deal with things like identification evidence, how reliable is memory, how does stress affect recall. Our scientific understanding directly shapes the legal rules we create to assess that kind of evidence.
So it's not just dusty law books, it's connected to how our brains actually work.
Precisely. It draws on psychology for witness behavior, logic for structuring arguments, philosophy for concepts like truth and fairness. And then you have broader public policy concerns, protecting privacy, maybe, and fundamental legal principles like the presumption of innocence influencing the rules, too. It's a real melting pot.
It sounds complex. And this complexity, these rules, they aren't applied the same way everywhere, are they? The guide mentions variations.
That's a really crucial point to get your head around early. The rules of evidence are at their most developed, their most strict, in criminal trials in the Crown Court, especially when there's a jury.
Why they're particularly.
Well, the stakes are highest, aren't they? Someone's liberty is on the line. So the rules are designed very carefully to protect the accused, to make sure the jury isn't swayed by unreliable or unfairly prejudicial stuff. That context, the serious criminal trial with a jury, is the main focus for a lot of your study.
Okay, strictest in the Crown Court. What about civil cases? Like contract disputes or negligence claims?
There, the guide says the rules are considerably relaxed. Most civil trials are heard by a judge alone. The judge is a legal expert, expected to be able to weigh evidence appropriately without needing quite so many rigid exclusionary rules as a lay jury might. So things that wouldn't get near a jury in a criminal case might be admissible in a civil trial before a judge.
Interesting. And magistrates' courts, where less serious criminal cases are heard.
Again, different. Trials there are usually before magistrates, either professional judges or lay justices, but no jury. The guide says the rules are different to some extent in practice. The formal law applies, but perhaps the application is a bit more flexible than in the Crown Court, partly because of the slightly less formal setting and no jury.
And then things like employment tribunals or arbitration.
Right at the other end of the spectrum. The guide says there's often little or no application of the formal court rules of evidence at all. Those bodies often have their own procedures, maybe prioritizing speed or a different way of getting information, rather than the strict evidence rules you'd find in court.
So you really have to know the context. Criminal, civil, magistrates, tribunal. It dictates the rules of the game.
Absolutely. Evidence law is definitely not one size fits all.
That variation is something students need to grasp. And the guide also talks about the nature of the law itself. It's not just a simple code.
No, definitely not. And understanding this is key. The guide describes evidence law as a mixture of principles, rules, guidelines, and discretions.
It's a mixture. Okay.
Yeah. You've got broad underlying principles like relevance and fairness. You've got specific, sometimes very detailed rules from statutes like the Police and Criminal Evidence Act, PACE-E, which you'll spend a lot of time on, and from case law, judge-made decisions. Then there are procedural guidelines, and crucially, areas where judges have quite a lot of discretion, leeway, to decide whether to admit or exclude evidence based on the specific facts of the case before them.
So it requires judgment, not just rule following.
Exactly. You need to understand the why behind the rules, the policies, the principles, to navigate that mixture effectively.
Okay, that makes sense. A sophisticated understanding is needed. Right, so we know what it is, why it's crucial, where it applies differently, and its mixed nature. Let's shift gears to the really practical stuff, the study roadmap the guide provides. It kicks off with what sounds like a core philosophy.
It does, and they really hammer this point home because it's so important. The absolute core message is success comes from understanding, not rote learning.
Understanding, not just memorizing.
Precisely. You cannot just memorize lists of rules or case names and expect to do well, particularly in the exam. You need a critical approach. You need to engage with the material, question it, understand the policies behind it, see its limitations, and most importantly, you need to be able to apply the law to a set of facts.
That idea of a critical approach seems key. What does that really mean in practice?
It means not just accepting what you read. It means asking, why is the rule like this? Does it work fairly? Are there better ways? It means seeing the connections between different rules and principles. It's about active engagement, not passive absorption.
Okay, understanding, application, critical thinking. Got it. How does the guide suggest we actually tackle the module itself, chapter by chapter?
It gives a very clear step-by-step approach. It's designed for logical progression, building knowledge piece by piece. First, start with the module guide. It's your roadmap.
And follow it in order.
Yes, crucially, work through the chapters sequentially. The guide strongly advises not to skip ahead to topics you might find more interesting at first glance, like, say, hearsay or character evidence.
Why is sticking to the sequence so vital?
Because the guide is structured to build on basic foundations. The early chapters, especially Chapter 2, which covers fundamental concepts like relevance, admissibility, the rule against hearsay might seem complex, but the guide is really clear. Getting a solid grasp of Chapter 2 makes everything that comes later much, much easier to understand.
So it lays the groundwork.
Exactly. Even if Chapter 2 isn't a standalone exam topic itself, the concepts in it are vital for answering pretty much any question involving whether evidence can be admitted, which is most of them. It's the bedrock.
Yeah.
Build it properly first.
Makes sense. Lay the foundation. What about the actual materials? What's in the student toolkit?
The guide outlines the essentials. Obviously, the module guide itself is your starting point, your structure. Then you need the core texts.
The main textbooks.
Yes, your primary source for the detailed law. The guide specifically recommends authors like Chu A. Chu, Evidence and Durston, G. Durston, Evidence, Text, and Materials. You'll likely spend a lot of your study time deep in these books.
Okay, core texts. What else is essential?
The essential readings. The guide is very direct about this. You must read this material when it's referenced in each chapter of the guide.
Must read, not optional.
Not optional. These readings often contain detail or cases the guide only summarizes, and the guide explicitly says this is where you'll find information needed to pass the exam. Don't skip them. Read them when the guide tells you to. Integrate them as you go.
Okay, guide, core text, essential readings, and I guess the actual laws and cases themselves.
Of course. You'll need to get familiar with numerous specific case reports, reading the judgments and the relevant statutes, the acts of Parliament that shape evidence law, PACE being a major one.
Right. Those are the must-haves. Does the guide mention other helpful resources?
It does. Things that are strongly encouraged to deepen understanding and build that critical perspective. There are additional textbooks. Authors like Dennis, Monday, Roberts are mentioned. Often, extracts are available through your university's VLE or online library.
So you can sample different styles.
Exactly. If you find one author explains things in a way that clicks for you, the guide suggests maybe getting their book. Different perspectives can be really helpful.
And then there's something the guide says you absolutely must get.
Yes, a statute book. Not optional. Totally essential. You have to get a current statute book that includes the key evidence legislation.
And you can take it into the exam.
Yes, an authorized version is allowed in the exam. But, and this is crucial, you can only underline or highlight in it. You absolutely cannot write notes or annotations if you intend to use it in the exam. They check this.
So just having it isn't the magic bullet.
Not at all. The guide really stresses this.
Yeah.
It's useless in the exam unless you're already deeply familiar with it. You need to know where things are, how the acts are structured. Statutes can be dense, difficult reading. The advice is to take your time, read the sections the guide refers you to several times to really get the details.
And keep it up to date.
Yes.
Yeah.
Try to get the latest copy you can. Laws get amended. An old statute book could be misleading.
Okay, statute book essential. Familiarize yourself with it. What about keeping up with new developments and getting those critical academic perspectives?
That's where legal journals come in. The guide highlights them as important for two reasons: keeping up to date with cases decided after your textbook was published, and accessing academic writing.
Which feeds into that critical approach again.
Precisely. Journal articles provide analysis, critique, discussion of reforms, vital for developing your own informed perspective. Your VLE and online library should give you access to many of these.
Does it recommend specific journals?
Yes, it gives some helpful pointers. For keeping up with recent criminal cases, it suggests the Criminal Law Review, which often has helpful commentary explaining the significance of new cases and the criminal appeal reports.
Okay.
For shorter articles, maybe the New Law Journal. For deeper, more academic articles and case notes, the big journals like the Law Quarterly Review, the Cambridge Law Journal, the Modern Law Review, and there's even a specialist journal, the International Journal of Evidence and Proof.
Wow, quite a few options there.
There are. The message is clear. Cover the core texts and essential readings as a minimum, but reading more widely in journals really supports your learning, helps you think critically, and see how the law works in the real world. Use the library resources.
Right, okay. So we know the what and the why, and we have our toolkit of materials. Now let's really get into the nuts and bolts of how to study effectively. The guide provides a very specific process for working through each chapter.
It does, and it's all about active engagement, not just passively reading the words on the page. It lays out clear steps.
What's step one?
First, read the chapter's introduction, get the overview, see what's coming.
Okay.
Step two, check the references for the core text and essential readings right at the start. And the key here is, don't just note them down for later. Read them when the guide prompts you to, as you work through the chapter's content. Integrate them. Also, note any further reading suggestions for later exploration.
Right, read as you go. Step three.
Look at the learning outcomes listed for the chapter. Before you dive deep, understand what you're supposed to be able to do or know by the end. Keep these goals in mind as you study.
Okay, know your objectives. Step four sounds important, checking progress.
Yes, very. As you finish sections within the chapter, you'll often find a reminder of learning outcomes for that section. Stop and check yourself honestly. Have you actually grasped those points? The guide is very clear. If you feel you have achieved the outcomes, then it is safe to proceed. If you do not, you should go back over the work until you do. It's a self-correction mechanism. Don't build on shaky foundations.
That's crucial advice. Don't just plow on regardless. Step five, quizzes.
Yeah, at the end of the chapter, there's usually a quick quiz, often multiple choice. Attempt these before looking up the answers, which are usually at the back of the guide. It's a good way to check your recall of key points.
Okay. Now, step six involves activities. How are these different?
Activities are learning exercises, not just memory tests. Their purpose is to help you learn and understand important, often tricky issues. They make you think, formulate responses, maybe apply a rule, and practice your legal English. The guide stresses they often don't have simple right-wrong answers.
So more about the process of thinking it through.
Exactly. And you must attempt the activity before you look at the feedback provided later in the guide. The value comes from wrestling with it yourself. If your attempt wasn't quite right, analyze why. Did you misunderstand something? Need to reread. They're vital for developing those application skills.
Active learning. Makes sense. And finally, step seven, self-assessment questions or SAQs.
Right. These are different again. They are mainly factual questions to test your memory of key definitions, rules, case names, statute sections, etc. The answers are directly in the text you just read, so there's no feedback provided in the guide itself for these.
So how best to use them?
The guide suggests maybe getting a friend or family member to quiz you using the SAQs. That forces active recall, pulling the information out of your brain, which is much better for memory than just rereading.
That's a really structured, active way to approach each chapter. You can see why skipping ahead would cause problems. Now, the guide also gives us the 10 golden rules for studying evidence. These sound like absolute must-dos.
They really are. They encapsulate the core wisdom for tackling the subject successfully. They're presented as principles to live by throughout your studies.
Let's go through them. Rule number one.
Rule 1. Learn each topic as you study it and revise frequently. This hits that crucial point again. The guide says flat out, evidence cannot be crammed.
No last-minute miracles here.
None. The way concepts link together, the need for application skills, the sheer amount of material, it demands ongoing work and regular revision right from the start. Keep going back over things.
Okay. Consistent effort, continuous revision. Rule 2.
Read each chapter in your textbook at least twice. Sounds simple, but it's powerful. Legal texts are dense. The guide acknowledges that what seems really confusing the first time often clicks into place on a second or even third reading. Be patient. Let it sink in. Repetition aids understanding.
Good advice. Sometimes you just need to see it again. Rule 3.
Read as many of the important cases as you can. Textbooks summarize cases. They have to. But the guide warns that summaries can sometimes simplify things too much, hindering real understanding.
So go to the source.
Where possible, yes. Reading the actual judgment or key parts of it lets you see the judge's reasoning, the specific facts they focused on, the arguments they considered. It gives you a much deeper feel for how the law is applied. Don't just read about key cases like, say, R.V. Hansen on bad character. Try to read Hansen itself.
Deeper understanding from the primary source. Rule 4.
Read as much of the recommended further reading as you can. And the guide gives a specific reason why. This is important for essay questions in the exam.
Direct exam relevance there.
Absolutely. Further reading, especially academic articles, gives you the critical analysis, the different scholarly viewpoints, the reformed debates, all the stuff you need to write a strong analytical essay that goes beyond just describing the rules.
Feeds directly into that critical approach. Rule 5 is about notes.
Yes. Take full notes of everything, lectures, tutorials, all you're reading, textbooks, articles, cases. Keep them organized. The guide specifically suggests using a loose leaf file.
Why loose leaf?
So you can easily slot in new material, later updates from journals, notes on further reading, maybe tutorial answers right into the relevant topic section. Keeps everything together logically.
Good organization is key. Rule 6 brings us back to the statute book.
It does. Read with a book of statutes at hand. We've said it's essential, and this rule reinforces using it constantly alongside your reading. You can take it into the exam, but only if you're familiar with it.
Because statutes are hard work.
They really are, often complex wording. The guide says read the relevant sections several times while you're studying the topic. Look up the sections mentioned in your textbook or cases. That constant exposure builds familiarity.
So it becomes a useful tool, not just exam baggage. Now, Rule 7 sounds really interesting, condensing notes.
Yes, this is, I think, one of the most practical and powerful techniques the guide offers. Rule 7. Condense your full notes into a skeleton set of notes.
A skeleton set.
Yes. And the guide stresses, your own skeleton notes, made through your process of understanding and boiling things down, are infinitely more valuable than borrowing someone else's summary. The act of creating them is a massive part of the learning.
Okay, how do they suggest you actually do this? Is there a method?
A very specific, effective method. Get a bound notebook, maybe like a traditional counsel's notebook, divided into sections for each topic. When you've thoroughly studied a topic, go back through your detailed loose leaf notes.
Right.
Then on the right-hand page of your bound notebook, write down the essential structure, the main rules, headings, subheadings for that topic. Crucially, next to each rule or point, jot down the key case names and statute references that support it. Just the references.
So right-hand page is the structure and the legal authorities. What about the left?
On the left-hand page, directly opposite, you write a very brief summary. The guide suggests no more than 3 or 4 lines of each key case you've listed on the right. Just the absolute essence. Core facts, key legal point relevant to the rule opposite.
Structure and sources on the right, super brief case summaries on the left. What's the final killer step?
This is the active recall part, the guide says. Put your skeleton notes aside. Get some scrap paper. And try to write out from memory the structure and key references from the right-hand page. Reconstruct the headings, the rules, the case names, the statute sections.
Test yourself.
Exactly.
Yeah.
Then, compare what you wrote from memory to your actual skeleton notes. See what you missed, what you got wrong. Then repeat the exercise for the bits you struggled with. Keep doing it until you can reliably reproduce that section from memory.
That sounds intense but incredibly effective. Forcing retrieval like that really cements it in your mind.
It combines structured notes with active recall. It's gold. Rule 8 is about practice questions.
Essential exam prep. How should you practice?
The guide suggests a 2-stage approach, using the sample examination questions provided. Stage 1. Practice with your notes initially. Pick a question. Spend maybe 15-30 minutes reviewing your notes, planning an answer structure, then put the notes away completely. Set a timer for 35-40 minutes, typical exam time per question, and write the full answer without looking back at your materials.
Okay. Plan with support, then write under exam conditions. What's stage 2?
Stage 2 is the full unseen practice. Choose a question for a topic you've studied and revised. Start the timer for 35-40 minutes. In that time, you have to read the question, make a plan, and write the complete answer. Just like the real thing.
Mimicking the exam pressure.
Exactly. The guide says this practice is vital for developing the skill of expressing yourself clearly and logically under time pressure, tackling questions systematically, and reading them carefully to spot all the issues.
Invaluable practice. Rule 9. Keep up to date. We touched on this.
Yes. Law changes. Textbooks go out of date the moment they're printed, really. So you must use things like the pre-exam update the university provides. Check your textbook publication dates. Keep an eye out for recent major cases or legislation using journals or legal websites. Stay current.
Essential. And finally, Rule 10 sounds quite practical.
It is. Try to see the law in action. If you can, go and watch some criminal trials, ideally in the Crown Court.
Why is that helpful?
Seeing how evidence is actually presented, how advocates argue, how judges rule, makes the abstract rules feel much more real. The guide specifically suggests paying close attention if the jury is ever sent out. Those arguments lawyers have in the jury's absence. They're very often about points of evidence. Admissibility battles, procedural points. Watching that live gives you fantastic insight.
Bringing the subject to life. Great advice. The guide also briefly mentions study time.
Yes. It says, set aside specific time each week. Plan to ramp it up in the run-up to the exam, maybe the last 6 weeks or so. But it also acknowledges everyone's different. The real goal isn't clocking hours, it's studying until you know the topic thoroughly. Plan your time carefully. Build in that continuous revision from the start. No cramming.
Quality and consistency over quantity.
Right.
So we've got the law, the resources, the study process, the golden rules. Let's talk about the end game, the examination. The guide gives some pointers, but starts with a big warning.
A really important one. The information on the exam format is based on how it was when the guide was written. The university can change the format, the style, the number of questions, anything. So the absolute #1 rule for the exam is always check the rubric and instructions on your specific exam paper when you sit down to take it. Don't assume it's the same as last year or the sample questions.
Crucial advice. Read the paper first. Okay, but assuming a similar format to the past, what kinds of questions might appear?
At the time the guide was written, it typically involved a choice between essay questions and problem questions.
And they test different skills.
Yes. Essay questions require you to organize your knowledge on a topic, address the specific question asked, and, crucially, critically evaluate the law you're discussing. You can't just describe the rules, you need to analyze them. Are they effective? Fair. What are the arguments for reform?
So analysis and evaluation are key for essays. What about problem questions?
These test your ability to apply the law to a specific factual scenario. You need to read the facts carefully, spot the legal issues that arise, state the relevant law accurately, citing cases and statutes, and then apply that law to the facts to advise the fictional characters or predict a likely outcome.
And what if the law is uncertain on a point in the problem?
Good question. The guide says if the law is unclear, you must explain why it's unclear. For example, conflicting cases, ambiguous statute. Then, you need to make a reasoned judgment call. What's the most likely decision a court would reach? And you have to give your reasons, supporting your conclusion with legal arguments. Application is key, but the guide notes most problem questions also offer scope for some critical comments on the law you've just applied.
So application first and problems, but still room for critique. It seems that critical approach is vital for both types of question.
Absolutely essential for both. Examiners are looking for it, maybe more sustained evaluation in essays, but critical awareness needs to show in problems too, perhaps commenting on the fairness or workability of a rule you've applied.
And how does a student actually develop this critical perspective? The guide says just reading the textbook isn't enough.
No, it's not. To satisfy the examiners on criticality, you need to develop independent thought. The guide suggests several ways. First, think for yourself. When you read an argument in a textbook or article, question it. Is it convincing? What are the counter-arguments? Don't just passively accept it. Second, read around the topic. Look at different authors, read journal articles, look up law commission reports if relevant. Get different perspectives. Third, discuss problems with tutors or lecturers if you can. Talking it through clarifies your own thinking. And fourth, crucially, discuss problems with fellow students. Arguing about how a rule applies, explaining it to someone else, these are incredibly powerful ways to deepen your understanding and spot different angles. You also must be aware of major reform proposals and criticisms of the current law, which again points back to reading those recommended articles.
So criticality comes from active engagement, questioning, reading widely, discussing. It's a skill you build. Does the guide mention any specific types of problem questions to look out for?
Yes, it highlights one particular type. Questions that deal only with the directions a trial judge should give to the jury at the end of a trial.
Why is that different?
Because in that scenario, all the evidence is already in. The jury has heard it. So questions about admissibility, whether evidence should have been allowed in, are generally no longer relevant. Your focus shifts entirely to the judge's summing up. Did the judge explain the law correctly? Summarize the evidence fairly? Give the right warnings or directions about specific types of tricky evidence like identification or silence. It requires a different focus.
That's a very useful tip. Knowing what not to talk about is as important as knowing what to talk about. And one last piece of practical exam advice from the guide.
Yes, read the examiner's reports from previous years.
Why?
Because the examiners write these reports, they tell you about common mistakes students made in past exams so you can avoid them. They often give examples of good answers or good approaches. It's basically free insight into what the markers are looking for and how to impress them. A really smart strategic move.
Learn from the past. Excellent advice. Wow. Okay, we have really unpacked this introductory guide today. We've looked at what evidence law actually is, why it's so incredibly important for practice. We've explored the resources, the essentials, the recommended extras.
We've walked through that detailed step-by-step process for tackling each chapter actively.
And dived into those 10 golden rules for studying that skeleton note technique. Sounds like a real game changer, along with a structured exam practice.
Definitely. And we've looked at the exam itself, the potential question types, the absolute necessity of that critical approach, how to develop it.
It really feels like a comprehensive blueprint, doesn't it? Laid out by people who know what works.
It is. And following this advice, really taking it on board, it's not just about getting through a module or passing one exam. It's about building a genuinely deep understanding of a fundamental legal area. It's about developing the skills, the analysis, the application, the critical thinking that you need to be a good lawyer.
It's clear that studying evidence law is challenging the guide doesn't hide that. But with this kind of structured approach, the resources available, and that constant focus on understanding and applying the law critically, well, you got the tools you need.
Absolutely. The guide gives you the map. It's your hard work in following it that gets you there.
So, maybe a final thought for everyone listening, something to chew on as you get stuck into your studies. Given how much evidence law has to grapple with the unreliability, the fallibility of human perception and memory, something the guide hints at with chapters 6 and 10, what does that really tell us about the immense challenge and the responsibility involved in trying to find factual truth in a courtroom, especially when so much is at stake?
That's a deep one. Or maybe consider the different ways the rules are applied strict in the Crown Court, relaxed in civil trials, almost absent in tribunals. What does that variation tell us about the underlying priorities of given parts of the legal system? What balance are they striking between accuracy, fairness, efficiency, protecting rights? Lots to think about beyond just learning the rules.
Definitely food for thought. Just to remind everyone, the source material we've been discussing is from the University of London's module guide, made available for its students. This deep dive has been for educational purposes only, and it's brought to you by Sinorbit Academy, Sri Lanka.
And from both of us, we sincerely wish all of you studying this challenging but fascinating subject the very, very best of luck for your exams.
You've got the roadmap. Now go make it happen. Thanks for diving deep with us today.
Until next time.